All right, this is part two of 2 parts of one. This is part two of a video. I'm sorry, I can't get it right. This is part two. This video is a continuation of part one. Now, I was just stating that the First Court of Appeals is preventing us, and that's why I'm saying they're committing a crime, because the court has issued an opinion. When you, I got a CD with all the filings, so what we need, complete thoughts. My mind raced so fast. Get the filings so the public, y'all can see what we brought to the First Court of Appeals attention. Let me start here at Supreme Court, members of the Supreme Court, because I'm going to have to find out if you all know that we're trying. It's like we're knocking at the door, at the window, and people stopping us from getting in. Because clearly, 9 members of the Supreme Court. So I got to make sure. Nah, we finna do a food and water strike in the House. We not being heard. Okay, people, look, world. People have seen the video. You have not, I don't think, seen what CPS has stated in court. Brandy, it's hard, man. Y'all think, man, we need to be investigating Hillary Clinton. That's who needs to be. You don't know what's going on here. Supreme Court members. Judge Phillips has committed a crime, an evil crime. And the members of the First Court of Appeals have allowed themselves to be bribed. And they're protecting him and CPS and Memorial Hermann Hospital. Complete stop. Protecting them. That's when you take the American people of the United States to be complete damn fools. And these people, they don't expect you to care about what happens to me. They want you, so only let the window up so to make sure the audio is quality audio. Members of the Texas Supreme Court, the clerk of your court would have me to believe that you, members, have 3 times denied motions to transfer this case from the First Court of Appeals, when I've made obviously clear that these members of the First Court of Appeals are corrupt and obviously have accepted a bribe from obviously Memorial Hermann Hospital. That is a giant billion-dollar corporation. A giant billion-dollar corporation. People, eventually, normally when I start off with my videos, I get excited, but I'm frustrated. But when you have the governor of the state of Texas himself, and you have a appellate federal court, one step lower than the highest court in the United States, which is the Supreme Court of the United States, telling you that the state of Texas has committed a crime, and that the 5th Circuit has stated in that case I cited, Gates versus Texas Department of Regulatory and Protective Service, has committed a crime. The 5th Circuit said it. What courts do? They don't make law. They apply law. The 5th Circuit Court of Appeals does not sit as a state court of appeals. That court, through her judges, deal with a federal question. If there be no federal question, that court does not have jurisdiction. So when the 5th Circuit said that the state of Texas cannot come into, from this day on, July 8th of 2008, the United States Court of Appeal for the 5th Circuit in Gates versus Texas Department of Regulatory and Protective Service told Texas, from this day on, don't go in nobody else's house without a warrant, an emergency, or a consent, and take anybody's babies, unless there be otherwise an immediate emergency right then existing. Right then existed. And an example of an emergency would be like in the case of 9/11, where those buildings were on fire. The fire department did not have to go and obtain, I don't even think state law would require fire department fighters to obtain a warrant to go into the Twin Towers to rescue anybody. It does not. They had no emergency. Even if there were child abuse people at the hospital, you can't come in my house and get him, because you shouldn't have never, if that were true, you can't come in the house and get him, my child. Unless when you get there, you got to get, and you don't have a warrant, and you don't have my consent to come in, there must be an emergency. And here, the petition that CPS filed, the name of the petition is to terminate the parental, it's called Petition Affecting the Parent-Child Relationship and to Terminate Parent-Child Rights, something like that. And it does not include, there's a separately filed affidavit, which is not the petition itself, that states that the reason that CPS violated the Fourth Amendment to go into my house, even though God gave me the right to be secure in my house, papers, and effects against unreasonable searches and seizures, unreasonable is that concerns for my mental health stability. But the Fifth Circuit responded to that, saying mere possibility, if that's what they were concerned about or pretending to be concerned about, is not enough to enter in a due process context someone's house without a warrant or consent. So if they are trying to say, and I use the word trying deliberately to say here, as well as in violation of Texas' own law, Texas Family Code Section 262.104, at that time Subdivision A, Subdivision 2, Subsection A, Subdivision 2. Prior to any amendment in 2017 to that code, that the only way, even under Texas' own law, that even Texas recognized she committed a crime under our own laws, because that statute tells you that, in essence, you can it uses the word only on the information of another, such as Memorial Hermann Hospital, someone that is employed by it calling in, based upon that information corroborated by personal knowledge of Paul Gonzalez, that at the time that you see a need to remove a child or children, that child is facing right then a cobra rattlesnake, or cobra snake, or rattlesnake. The house is on fire. You come up for example, you come up to the house and the baby is there by itself. Nobody's watching the baby. It's weed or marijuana everywhere. Those are places the baby or children, and it affects their safety, their health. That's an emergency. You don't go get no one. Well, I see snakes in the house. They raising snakes, deadly snakes, and you go get a warrant. You go get that baby up out of there. Then you go get yourself a warrant. And in my case, the Fifth Circuit told me that's not enough. So once the Fifth Circuit federal court said, when the federal judges said it, you can't do it. That's what that means. And you want to know why I'm calling? I've been trying. Now, Brandon and I have been trying to speak since the day after. We've been trying to speak and tell our side of the story, and Judge Phillips wouldn't let us do it. So, all right, we have to go through. I'll come back and modify and expound on that. So, we have to go a whole year, and there's so many things I have to say here. Before, okay, well, we'll beat them in the heart the first court of appeals until I get, and then we go to first court of appeal, and the first court of appeal is blocking us from getting this out. Brandon has not been hurt. Look, people, when the first time Brandon and I, look, in suing us for our child, they already committed a crime. They must hold a Fourth Amendment hearing. Why? Because they went in our house and took our child. God gave us the right to be protected from that state action. So the purpose for the hearing is to justify violating the Fourth Amendment. Well, on Monday, May 8th of 2017, Judge Phillips don't take the bench. My mother is there. Paul Gonzalez, the man that actually took our baby, is there. I am there. Judge Phillips does not come out. No hearing was held. He signed no order. And the federal judges have said that that is sent. And even on May 18, 2017, he even asked us, do we have emergency orders? You mean you don't know? So what I'm trying to tell, and so what he do? He never held the hearing, which is a crime. The FBI. So look, pursuant to Title 18, United States Code, Section 1746, Subdivision 2, for allegations unsworn before a magistrate or notary public, and in the United States, I, Ronald Dwayne Whitfield, a person of over the age of 18, of sound mind, and acquainted with the facts I'm about to state herein, henceforth, are true, correct, and not misleading, under the pains and penalty of perjury. I respectfully submit that the allegations in the department's petition, the material facts that, if they do at all, constitute child abuse, such as I claimed I knew President Donald Trump, it's a lie. I never told anyone at the hospital I knew President Donald Trump. I never told any of the doctors and nurses that I was a lawyer. I never told police officers at the hospital. You see the video. You look at what the woman came to court. Anything that, look, it make it simple. I deny all wrongdoing. Any wrongdoing. I deny every and each. I like to be speak like I got some damn sense. I deny each allegation that could even possibly constitute child abuse. I deny that I was swinging my child around from side to side, yelling or screaming, because yelling and screaming means the same thing. I deny that I told anyone in the hospital that I knew personally, at least, President Donald Trump. Donald Trump never came up. I deny that I told anybody that I was a lawyer. I deny that, what else they said and my wife is not here. Will not purport to speak for her right now. I deny these allegations. I deny these allegations under pains and penalty of perjury. Now let's go to Texas law. Pursuant to Texas Civil Practice and Remedy Code, Chapter 132.001, et sequential, I, Ronald Dwayne Whitfield, a person over age 18 of sound mind, acquainted with the facts that I'm about to state, say that they are true and correct and are not misleading. As previously stated under the federal statute, I deny these allegations as being true. I deny the whatever they allege. Whatever they ain't alleged, god doggone thing. Before we can even get to people coming into the courtroom, before we can get to people even coming to the courtroom, I'm going to speak and still under perjury. I'm under perjury, so lock me up if I'm lying, people. Before we can even get to the courtroom, the state of Texas, through her Harris County attorney who drafts the petition, must plead facts, specific facts, which are true, which, if are true, would entitle the state of Texas to the relief that she seeks. In this case, the state of Texas did not allege any specific facts alleging child abuse against me nor my wife. Instead, the state of Texas through the Harris County Attorney, pled the statutory grounds for child abuse. Not one fact alleging child abuse was alleged against Brandy, and not one fact was alleged against me. When, because I don't know, I wasn't there. If CPS, the state of Texas, in fact received, obviously she did, information anonymously from someone named Lauren Freitag or Friday, employed by the Texas Memorial Hermann Hospital, making a false report of child abuse against me. If that were in fact true, the attorney that filed this, drafted it, or the paralegal, and the attorney that signed off on it, Emily M. Berger, whatever her name is, and presented it to the clerk and filed it for me. That petition does not allege any facts whatsoever of child abuse. Where's the court gonna get its subject matter jurisdiction? From an affidavit? Not incorporated into the petition itself? Well, okay, the Supreme Court would say, okay, assuming arguendo that they could do this, you can't, because we got under federal rule, Texas Rules of Civil Procedure, and federal practice rule, and federal rules of Civil Procedure Rule 10, subsection C, allows one to adopt by reference and incorporate into pleadings allegations from another pleading. On the state practice, I believe it's Rule 58. The petition does not adopt by reference the affidavit of removal, and even if it did, that we cannot have any what they call pro se hybrid representation, since the Department of Family and Protective Service was represented by the Harris County Attorney's Office. The affidavit must be struck because the court cannot consider, the department cannot be represented by a counsel and then have a officer of the state and the officer, they have not come out and picked up the trash. That's what I'm coming over here today, a 96-year-old Caucasian military veteran who put his life on the line to protect our country, and this is what he put his life on the line for our government to become corrupt, and y'all hating President Trump, who's for a rule of law, and we in a lawless United States. What's wrong with us? And you're mad at me because I'm not finna accept no bullshit. Me and my wife were not finna eat, but we already dying. You done took our child. We ain't can't how else longer can we live? But back to what we're talking about. They don't have a claim against my wife. There's no claim. The federal courts will tell you we don't have jurisdiction. The federal judge ain't gonna have no problem telling you, and you know you have no jurisdiction. So they've not yet came and collected the trash yet. The city of Houston. Them white folks out here ain't gonna hardly go for all this. White folks ain't finna go for all this. You taking their tax dollars, you can't, what is stopping the city of Houston from being timely collecting this trash? They never had, so the first court of appeals, these people have sworn to uphold the law, and then when I start demanding Congress step in and demanding, cause look at the harm. Can they give me back all the time from my child that I've lost through no fault of my own, like as if they don't receive, as if there's no laws for and against false report of child abuse. Now, when you go to the court and you look at what happened in the pleadings, how is it that these attorneys, Judge Phillips, had no legal authority to force attorneys upon Brandy and myself? He did that. And then the first court of appeal is lying as if we have, so I'm gonna expose it, what you're doing. When someone, from what I can see, people, when someone has, when you got the state of Texas committing crimes, they won't let us, what Brandy has to say and what I have to say has not been addressed. Brandy has this. The lawyer that Judge Phillips threw on her, put cement, so to speak, and made her herself. Did not ask Brandy, did not represent Brandy. There ain't no way is this lawyer asking Brandy, okay, Brandy, we've heard these allegations against you. You've heard what is written in the petition, which is nothing. You've heard what is stated in the affidavit against you, which is nothing. Look at the affidavit. Look at what Brandy's doing on YouTube. Leave. Yet they saying she's hearing voices telling her to kill herself. But what you seeing is Brandy, she's seeing something none of us are seeing. These people finna try to get my baby. They finna try to lie and get my baby. Leave, man. I'm trying to, she doesn't know the police off duty has told me, hold up, man, we need to talk to you. So I can't leave. I don't know they off duty. I don't know they off duty. I don't know what the hell going on. You know I don't know what's going on. You can listen to what's being said. I don't know what the hell going on. I don't know what the hell is going on. These people up here, they want to commit healthcare fraud. I don't know this at the time. We have not been heard, Justice of the Supreme Court of Texas. That's why I'm calling. You people, when it goes to what they call petition for review, that is discretionary. By the rules of appellate procedure, they don't have to grant that petition. That means the state. See, they knowing. Well, I can't. The federal courts have barred me out of court, but the Supreme Court of the United States has said that Whitfield may file sue Texas against criminal sanctions which may be imposed on him in criminal cases, but he cannot do so in civil cases. If I could get the Supreme Court of the United States now, I'm meant to say the Supreme Court of the United States, I'm not talking about the Supreme Court of Texas, I'm talking to them. This video is for them to know what I know now, what I couldn't know then in prison.